We'll have a roll call. So let's see. Members present, Diane Casey, Dr. Manuel Gonzalez, and Blaine Sabile. Members absent, Dr. Wayne Lee, Dr. Ivan Melendez, Edwin Reyes, Dr. Kelly Frazier. C, approval of the minutes, the meeting of November 6, 2015. Are there any corrections, omissions to the minutes?
No. Madam Chair, we will not be able to take that action today, though.
Okay.
Because you don't have a quorum.
Oh, that's right. I'm sorry. So we will skip number C, approval of the minutes. Are we going to have the video presentation, public comment?
Madam Chair, have you had a chance to see this video presentation?
I have not.
Well, you're going to be super impressed.
Good.
One of the things that, this is Brian Francis, Deputy Executive Director. One of the things that Bill wanted to do this year, or last year, is to get more information out there, YouTube videos and that sort of thing. You've experienced it before with the commission meetings, that often people have a different expectation of what can happen during the public comment portion. So we had this video developed for the commission meeting. We're going to have one that's specially tailored for advisory boards, but at this point in time, we're using this one for public comment.
And before you start, just for the record, that the roll's been called, it's not a quorum, but the discussion as it moves forward is just an informal discussion without any official action being taken. This is just for the record.
Right.
Thank you.
Charles, thank you. Madam Chair, the video stars our very own Mary Winston.
Mary Winston. Today, we're going to explain the public comment process for commission meetings.
And I'm Ken Sharp. We'll also explain the rules that you and the commission must follow during this process.
Members of the public may come to commission meetings to voice their opinions about matters under the commission's authority. This is the public comment part of the meeting. This is an opportunity for members of the public to have their voice heard regarding a subject that is not included on the meeting's agenda.
Now, as you might imagine, it would get confusing if everyone talked and the commission didn't know who they were or why they were there. The commission has a few rules to help make this an orderly process and give everyone who wants to make a public comment a chance to speak.
To make a public comment, you must first complete a public comment form. You'll find these forms on the table by the door when you first walk into the commission meeting room. Fill out the form completely, and when you finish, give it to the commission's administrative assistant so she can add your name to the list of speakers for the public comment part of the meeting.
The second rule is that you must limit your comments to 3 minutes or less. 3 minutes can be a very long time if you're nervous.
Yes, it can, but it goes by quickly. That's why it's very important to plan your comments carefully so you can make your point in the short amount of time available to you.
An important thing to remember is that you may not comment on any case the commission must decide during the meeting.
That's exactly right. The commission does not want to ignore you or your opinions, but because of the pending case, the commissioners might have to interrupt you and stop you from making those comments. That could be embarrassing, but more importantly, you will have wasted your time. The public comment portion of the agenda is for the commission to hear what the public has to say about issues that are not specifically listed on the agenda. The public comment period does not include debate about the issues. If the topic you want to talk about is already on the agenda, then you have to wait until the commission gets to that agenda item. You won't be allowed to comment on that topic during the public comment part of the meeting. Public comments are only for topics that are not on the agenda.
If you have a case pending before the commission, you'll get an opportunity to talk to the commission about your case when it comes up on the agenda. For that reason, you will not be allowed to talk to the commission about your case in the public comment part of the meeting. The commission will hear your case when it has to decide your case and when the commissioners have your case filed in front of them.
So those are the basic rules about making public comments at a commission meeting. You must fill out a public comment form.
You only have 3 minutes to make all of your comments.
You may not comment on any case the commission has to decide that day.
Any comments about a topic that is listed on the agenda must wait until the commission takes up that agenda item.
If you have a case pending before the commission, Commission, comments about your own case will have to wait until the Commission actually considers your case.
TDLR commissioners are good listeners and will consider everything you say, but keep in mind that they are not allowed to respond to your public comments. That's because the commission is only allowed to talk about things that are on the agenda. That way everyone, commissioners and the public alike, will know how to plan for each meeting.
We hope you find this information useful as you plan to make a public comment at the meeting of the Texas Commission of Licensing and Regulation.
And remember, if you ever have any questions, you can always call TDLR for assistance. While the staff at TDLR cannot give you any legal advice, they can answer basic questions about procedures at commission meetings, like offering public comments.
Thank you for watching.
Very good.
Very nice.
Nice job.
Yeah. That will help people out who really are interested in doing public comment appropriately. Speaking of which, do we have public comment today?
No, we do not.
So now we move to staff reports.
Madam Chair, Brian Francis for the Executive Office. Just a few things to bring you up to speed on. Every legislative session prior to this last one has prepared us for the one we just went through. It's probably the most involved, engaged, and will change the way TDLR does business going forward for the next 20 years. There was a number of programs that were transferred to TDLR through the Department of State Health Services. There'll be 13 programs coming to the agency, 7 in this biennium, 6 in the next biennium. Each of the programs this time around have an advisory board. November, we hosted probably 15 to 16 advisory board meetings for the whole month. That's going to be our world going forward. February will have a similar type of feel to it. The staff has been working extremely hard in trying to put the rules together and have the right infrastructure so that when the programs officially come on board, which will probably be around September or October of this year, then we'll be able to take it over very seamlessly. Well, with the new programs, there was a contingent rider to give us some revenue and give us some FTEs. We just got word 2 days ago that they've released the money, so you can imagine we thought we were going to have the money released on September and start making some of the purchases. We just got it yesterday, but we're grateful for the Juneteenth moment that we were delayed in notifying about our freedom, but it is a good thing nonetheless. So we're excited about that. Now we're going to start plowing forward and doing the work of buying the things that we need and setting up the IT system. Well, with the new programs, we've done some reorganization inside of TDLR to position ourselves. One of the things that we realized that, yes, licensing is a core competency and enforcement is a core competency. Well, now we're realizing that advisory board support is now a core competency for the agency. And to that end, under what used to be our public affairs group, it's now our Office of Strategic Communications, we've created an advisory board support unit and team. Tamala Fletcher, Delia Luna, as well as Mary Winston are heading up that group. So it's going to allow us to give a lot more personal service to the advisory boards because it is a full-time business, setting the meetings up, the agendas, hosting the meetings, making sure that the staff is available and the room's available. So it's been really involved. We've also planted some new FTEs throughout the agency. So in compliance, we're going to have those subject matter experts, whether it's the dyslexia or dietitians and that sort of thing. The same thing for licensing. They'll have a pod of folks who will ultimately be spread out across TLR's programs that have that Department of State Health Service expertise, and the same thing for the Customer Service Division. So there's a lot going on, a lot of moving parts, but now we're actually going to be able to acquire the new moving parts since we had a release of the funds. So that's been the real big thing. On September 1, the agency took over the responsibility for driver's training from the ESC 13 as well as DPS. So that is our function now. So we've been bringing and hosting that new activity under TDLR. So when I say we're changing dramatically. But it's exciting. My boss, Bill, loves, I would say a good fight, but it's not a fight, but he loves competition. And he sees this as competition, and he's really stepping up, doing the presentations and doing the visioning for us. So we're excited about it. The legislative update that I had for this group is House Bill 3315. It changes the name and allows us to change the composition of the advisory board. at the last meeting we went through, and I thought the group worked very well in having some good conversations about making sure that we maintain the heart and core of the advisory board on the medical issues, but we also bring in those other voices for the promoters who have an impact, because the rules impact their lives, and the promoters for MMA and for boxing. So there's really a lot of good work, Madam Chair. You'd be proud. They worked hard in your absence. And today, Charles, later on the agenda, will lay out the comment or comments we've received relating to the proposed comments. Our desire is that we listen and engage with the board as Charles is laying out those rules. And if there are any, if we get a sense of guidance or direction from the board, we will incorporate that into our discussion for the commission. But our desire is to continue to move forward with the rules and take those to the commission at their, is it February 9th or 10th meeting? 10th. February 10th meeting. So that's the plan, and Madam Chair, I am available to answer any other questions that you may have, or board members.
Thank you, Brian.
No question.
Thank y'all for being here, we appreciate it.
Compliance?
Oh, that hurts. Oh, that hurts, Greg. Oh.
Good morning, Greg Olivares, Combative Sports Program Manager. Today's compliance report, excuse me, starts out that we'll give you an update on the event stats and activities. Total starting from September 1st of this year up to December 31st. We've had 16 amateur MMA fights, 0 amputee boxing, amateur boxing, 27 professional boxing, 0 combination fights. The combination fights is usually boxing and pro MMA. That's 0. Professional MMA, 10 bouts. Muay Thai, 0. Kickboxing, 0, for a total of 53. TV events from September 1st to September 31st, we've had 10 televised fights from CBS, NBC, ESPN, Fox. We haven't had one of the big networks during this time, which is HBO, Showtime, but there's some coming up in the future. If it sticks the way it's going to be, well, that announcement should come out soon. Since the last commission meeting, advisory board meeting, we've had no new promoters meetings. So there's no new promoters applied for a license, but I have new licensed promoters coming up here in the next couple of weeks. That's our slow months are coming off of December and January, and then they start up usually right after that. And we expect a very heavy schedule and a lot of more new promoters and some old faces coming in because we're getting inquiries. One of the old faces, just for y'all's information, is Margarito, the Tornado. Antonio Margarito, that's his last name. Okay, he's planning to make a comeback. And one of the special guests that's supposedly getting licensed, getting ready to come to El Paso and fight is the actor Mickey Rourke. Pending he passes all his physical tests. So that's an added feature to that one event, and that's a new promoter who will be coming in within the next couple of weeks for his promoters meeting. Now, as far as the legislative implementation update, me, the staff, and the general counsel, we got together, we had a meeting as far as how to proceed this, and I think Charles is going to talk a little bit more on that. And then tracking injuries and medical report, that's something that was brought up. What we've put together, me and the staff, is we got a post-bout sheet that the doctor fills out already. The slots are very minimal, just for minimal information. Now we're expanding on the sheet where it makes it bigger, where they can actually put down how the fight ended. If it was a regular fight and they ended, they're just gonna put the regular suspension days and put, both fighters okay, that's it. Now, if they have an injury, we're gonna ask for them to be specific, whether it's concussion, a break, a tear, or something, so we could start a tracking system as far as what kind of injuries we're sustaining in this program. Because I know with the new Combative Sports Board, we're gonna have hopefully some people where we could get better understanding of some of these issues that are coming up in other sports, such as concussions, long-term effects, okay? So that'll be our tracking injuries and medical report, and we're gonna put that to work as soon as, like, we got a show this weekend, and most of them guys got the first reports going out to the doctors, so we can start tracking from now on. So hopefully the next meeting, that would be on our update of compliance as far as how many concussions were sustained, how many hospital visits, how many emergency room visits, and, and up to date like that. Any questions?
Are we gonna get any, this is Manuel Gonzalez, Dr. Gonzalez, are we gonna get any feedback from the hospitals after we send them off for x-rays and or CT scans? Do we get a follow-up from them?
Right now, I have Jim Erickson, the assistant program manager. He's getting with other states to see what forms are they using, if they have a form, as far as follow-up to the doctors, requesting that information. They would have released to them if we had to evac somebody to the hospital. That form would go with them, so the doctor can call at any time and get information. Is that what you're talking about?
Yes.
Yeah, as far as what the update of the fighter is, to release that information.
Now, for example, if we send them off for a CT scan, for example, and these guys are from Washington DC or elsewhere, how can we get the report back and see what the impression was on that CT scan, so that we can have records for the medical advisory board and for the for future fights in the state of Texas?
Basically, the way it's gonna work is the physician who does the pre-fight physical will have this extra form with him. And after he finishes examining the fighter or the contestant, he would have the contestant read this form saying that he releases information. Then the doctor would sign it, he would sign it, and the doctor would be in possession of this form at ringside. Now, if he was to have to send them for a CT scan and stuff, it would be the doctor's responsibility to get that form over to the hospital, to have that communication between that and the emergency room, that I got this form available to release information. That way, in case they say, we can't release that information, you say, yes, I got a form which the contestant signed, and, it should work like that. We've done it before. Some doctors have their own forms before. We're gonna try to,
Yeah.
get as close to that as possible.
If I may inject, I think that the discussion that we're having at this point is kind of a preliminary discussion, and that these are kind of some of the things that we've talked about that would kind of address the issue. But I think there's another concern that we have to focus on as well, which is, do we need to tweak the rules in order to make this happen? And so I didn't want you to think that it was just the form, but there may be an underlying process that needs to be put in place so that when the form is actually put in place, we've got rules to enforce them.
No, but my question was what happens is that once the fight is over, and you have, let's say, 2 CT scans and an X-ray of a shoulder and 2 lacerations, for example, all these people scatter from all over the country. Is there a mechanism where we can get that automatically sent to us?
And that's what I'm discussing in the context of tweaking the rules, because the fighter may have to be required to give authorization. And I think that if we just put it in a form without a rule to connect it up, it could be problematic. And so the fundamental points that Greg was making, I think, are the direction we're headed, but it's the mechanism to make it happen that I'm focused on.
Oh, I see. Okay.
So, Blaine Spiel here. Are we going to, without quorum, are we going to table some items and document what we're tabling? So we don't have I don't know if we can even have a motion to table some of these items, but.
There's no official voting going on at this point.
Understood.
This is more of a discussion to bring you up to speed in terms of where we are, but I think the process moves forward. but we wanted to move forward with your knowledge of that plan and execution.
And just to kind of follow up, Mr. Seville, the issues that are being discussed today won't die today because there's no final
Sure.
action. We're going to bring them back to the next meeting, and we'll even encourage the chair to make some work group appointments, because these are items that really are best suited for a smaller group to kind of wrestle with the details and then bring it back. And so we anticipate there'll be several work groups, and it was discussed at the last meeting, the need for doing a couple of those.
And I think that when we get to the rule, you'll see that discussion materialize that Ms. Francis just made reference to. There's one of the, and not jumping ahead, but there's a provision in the rules which sets up standing committees, which are work groups, to address these kind of issues.
Diane Casey, if I can kind of restate some of this, it sounds as though the ultimate aim is that when a fighter is injured here in Texas, is sent to a Texas hospital, that the Texas group will get feedback on what happened and what the status was, irrespective of where the fighter is, if he gets up on a plane or whatever, so that the next time this person fights in Texas, you've got some kind of historical record to build on?
Yes, ma'am.
Is that where you're headed ultimately?
Yes, ma'am.
You're gonna set rules in place and then work with the appropriate way to affect cooperation from hospital staff?
Yes, ma'am.
Okay.
Anything else?
Questions for Greg? Thank
All
you,
right,
Greg.
thank you.
Thank you.
Our next report is the Enforcement Division. Is that gonna be Ron?
Good morning, Madam Chair, Mrs. Casey, and board members. I'm Ron Foster. I'm a senior prosecutor in the Enforcement Division. I am presenting our divisional report. Now, just as a reminder and a brief overview, I'd like to explain the enforcement process for y'all and for the public. The Enforcement Division receives complaints and determines if a case needs to be opened. And if the case does get opened, it gets assigned to an investigator and investigated. The investigator is collecting facts and completes a report and then eventually sends that to a prosecutor. The prosecutor will review the case and determine whether or not to proceed to prosecute the case. If penalties and sanctions are going to be imposed, those penalties are going to be consistent with the enforcement plan that you've already approved. That enforcement plan has also been approved by the commission. It's important to keep in mind that not all violations necessarily result in a penalty or a sanction, because, as I said, each case is reviewed by a prosecutor. The prosecutor is going to take into consideration whether corrections have been made and, of course, the sufficiency of the evidence in the first place. So you may have cases that have insufficient evidence and they get closed, or if the prosecutor believes it's warranted, they may issue a warning on the case. If the prosecutor does proceed to prosecute the case, they will send out a notice of violations. In that case, we will always try to settle the case and come to an agreement with the respondent. In this case, it would be called an agreed order, would be the result. If the respondent actually requests a hearing, then we will end up going to the State Office of Administrative Hearings, the court, for the matter to be heard, and ultimately the commission will hear that case and issue a final order. Now, as you can imagine, if there are circumstances where the respondent does not respond at all to us, we proceed on the case and we will issue a default order against the individual. Now, you will see from your enforcement report today that that's exactly what happened in a number of the cases we have. We had 36 cases that were opened, 11 resolved. Remember, the resolution of a case does not necessarily mean the assessment of a penalty. It could have been closed, it could have been warned, or in the case of the 4 that have been highlighted for you, we issued default orders because the respondent did not respond to us timely. Now, one of those cases involved a failure to comply with the terms of a contract. basically the contestant did not show up to fight as agreed. In another case, the promoter failed to provide proper information to the contestant in order to file a medical claim. And then we had two separate cases of unsportsmanlike conduct. One of those, an individual contestant bit another contestant in the match. And in the second case, unrelated case, the second after the match was completed, the second jumped into the ring and started fighting with the referee and other individual security guards and such. So in those two cases, we did issue a 1-year suspension and $5,000 penalties. That's why you will see that it seems very significantly high, $11,500 in total penalties assessed. We've only collected $750, unfortunately, but as you may recall, that's actually kind of normal when you have default orders. When you don't come to an agreement with somebody regarding the penalty, very often it's difficult to collect those penalties. So we've collected $750. That was from the Kick-Ass Productions promoter. They've actually partially paid the penalty that was assessed in their case. They still owe us about $250. No one else has, none of those other case respondents have provided any payments on their cases. However, they are still suspended, or whatever other sanction is still applying to their case. So they will, those contestants will not be fighting. Do you have any questions regarding the enforcement report or any of the information I provided to you?
No question.
All right, thank you.
Okay, thank you, Ron. For the licensing division report, Chloe?
Good morning, Madam Chair and board members. I am Chloe Whalen, the licensing manager for the Combative Sports Program. Before you is my report for the FY16 numbers, or for statistics, and the to-date numbers as well. On the combined totals, I did make a mistake there and did not change that to FY16, so I'll make that change once I get back to the office. But if you have any questions, I'll be glad to answer them for you.
No, thank you.
Thank you, Chloe.
Thank you.
Section G, discussion and possible recommendation regarding proposal rule amendments.
Morning. Mr. Chairman, for the record, Charles Johnson, Assistant General Counsel. This agenda item is a draft of the proposed rule to implement the recent legislation, change the name of the advisory board and its composition. In the last meeting, a month or so ago, there was considerable discussion about how to balance the membership of the board in terms of keeping the focus to the extent possible on the medical aspects of the sport, while at the same time bringing voices to the table to talk about and discuss other issues within the industry that affect issues other than the medical concerns. And so what you have here in front of you today is a draft rule that attempts to balance those concerns. And so we start with the fact that this is a new section in the rules at 86.120. I'm sorry. We're repealing the existing 86.120 and replacing it with a new section, 86.120, which sets out the membership of the advisory board, starting with subsection A, which includes the requirement that there be 4 physicians, 1 boxing promoter, 1 MMA promoter, 1 combative sports license referee or judge, and 1 former combative sports contestant with a public member, which would give the board a total of 9 members. In subsection B, just merely requires that if a position requires a license, that the license has to be issued by the state of Texas, and this is mainly for the physicians that are on the board or in any of these past positions that would require, for example, a former, I think I just misspoke on that one. It's limited to the physicians. The others could be a licensed contestant or a former contestant or a judge or referee, not necessarily in the state, but have been issued a license at some point by the state. And Ms. Case?
Oh, I was just gonna say, it's not clear that that's totally for the medical profession, since a number of these other positions could be licensees. So you're saying at some point in their history with the industry, they have to have held some kind of Texas license?
I think I misspoke.
Okay.
It's for the positions that, the positions that require a license at the time of appointment to the board, which I think goes just to the physicians. And so I think I misspoke on that point, and apologize for that. But the rule goes on in subsection C to talk about the terms of membership, and so these are 6-year terms with altering expiration dates, which is similar to all the other advisory boards. There's nothing unique about it, just that it's being spelled out here. In subsection C is the obvious, which is you come and serve, but you don't get paid, same as all the other boards. And then we end up with the meeting requirements, which is pretty standard. There's nothing unique about this. And we go to subsection H, which is the piece I made reference to earlier about the appointment of standing committees. The thought here was that during the interim between your meetings, that you have a work group that's been established, and we can take issues to and engage in discussions. So when we get to your next meeting, it's not just a staff perspective, but a collective discussion based upon the work of the work groups that bring you back something that in a usable form. And so the idea there is to keep the board at some level engaged between meetings. And with that, the rule has been published in the Texas Register, and you receive 1 comment from the Texas Chiropractic Association. And essentially, their position is that the 4 positions, that should be at least 1 chiropractor in order to, I guess, represent the benefits that chiropractors can bring to the table in terms of their participation in this whole process. So we received 1 comment, and we kind of welcome your discussion on your thoughts about their request.
And
With
Madam Chair, Brian Francis, Charles, thanks for laying that out. Last Friday, the Texas Chiropractic Association met with the executive office, Bill and Michael Kelly, just to kind of elaborate a little bit more on their comments that they filed. One of the things that they pointed out is that the chiropractic industry has a lot of connection to assessing and being able to treat concussion-related matters. And so Dr. Ryder, who was with their group, spoke a little bit about the need to be able to evaluate concussions. They also made the curious connection that if it's just physicians that you have, then right now the pool of advisory board members on the physician side could include gynecologists and other non-combative sports-related physicians, whereas they were trying to make the argument that the chiropractic industry probably has a little bit closer connection to injury and concussion than some of the groups that could be pulled under the concept of physician. The way I understand the request is they are not saying create a chiropractic specific seat, but just allow a chiropractic doctor to be considered along with physicians. So I just wanted to clarify what their comments were.
Thank you, Brian. That was gonna be my question. Did they want a specific identified seat for for a doctor of chiropractic?
Yeah, when I initially read their comments, I had the same idea, and they didn't raise that, but at their discussion, they elaborated that it just simply says, include physicians, doctors of chiropractic, and allow the commission to have a broader pool from which to select.
Is there comments on this? My comment is very straightforward. First of all, in the last meetings that we've had, my point has been that there's, the physicians working as ring physicians are very varied, and I've been with pathologists, pain management guys, that really, a lot of these guys just want to watch the fights from up close. And, you know, I've not brought this up. And I think it's very important that the people that are taking care of our boys in the ring should have trauma. If they do trauma at work, they should do trauma on ringside. If you don't do trauma at work, you shouldn't be up there, you know, just to watch a fight. Now, that's one thing. My other comment about this is that chiropractors are not MDs. And I've never seen a chiropractor in my life treat head traumas in my life. And I don't think any hospital in the United States has a chiropractic guy leading the trauma team. And I think we have to be very minded about that, because you open the door and things happen. You know, chiropractors, if you all know, they're basically physical therapists. And they work on spines and whatever they do. Voodoo medicine, a lot of this stuff. But they do not work with concussions, they do not work with head injuries, and I think it's very important that if we're gonna go that route, that you study where in the state of Texas a chiropractor is allowed to treat trauma patients. And I think we should go on that. We should not go on their word, because they can tell you anything. But I think we can go by the American Board of Surgery, American Board of Trauma, American Board of Vascular Surgery, anybody that does trauma, ER physicians. I don't think you'll find one chiropractic guy in there. I don't think they even know what an ER looks like. So with that in mind, that's just a comment I have to make. I think it's
No,
it would
we
be
appreciate the feedback.
extremely dangerous.
Yeah, actually, those are the kind of comments that I think we're looking to solicit, because I think they go to the underlying heart of who should be on that board.
Absolutely.
Yes. And I was going to just, Diane Casey, I was going to reiterate just for a moment that, as I understand it, what your desire is today from us is comments, observations, discussion that you can take back to the commission when they evaluate and determine
Correct.
their position on this rules. And I would basically say, I think the focus of this committee has always been the health and safety, I mean, primarily of the sport, which long-term has got to be good for the sport. And I clearly understand the commission's desire not to move away from that. And so with the new board, I do think all care needs to be taken to keep that in mind and to keep the quality of the ring care from the physician side intact. Perhaps on the application form, we could end up adjusting it a little bit to require some detail on trauma experience, so that you would have some background information coming in to assess your application, your candidates, or whatever.
Manuel Gonzalez, Dr. Gonzalez, the minimal that in the state of Texas, probably in the United States, for trauma care is at least passing the ATLS, acute, the trauma life support system. Of course, that's it's awfully general for a ringside physician, because they don't deal with you know, fractured, bleeding legs and stuff like that. But they deal a lot with blunt trauma to the head, blunt trauma to the abdomen, and at least to us, to be able to work in the emergency room, we have to pass the ATLS. And it's required by the state of Texas that if you're going to do trauma in the emergency room, you have to pass the ATLS, which is you know, that might be you know, and there's certain requirements to take that exam, and one is that you have to be practicing trauma.
And as I kind of interpret what we're suggesting, is not necessarily to change the rule, but to look at the form and the internals of the applicant.
if I may go a little further, a little bit off the side here. Again, I brought last time up, and I think it goes with this, is that the physicians that are practicing, ring physicians should have, we should, in the state of Texas, we should have a letter from their malpractice carriers saying that they are covered to do trauma. And so that we're covered, and we're covered as a committee and as a body. Because a lot of these guys are not covered by the malpractice insurance to do head trauma cases, like, you know, a pain guy that never goes into the hospital. A lot of internal medicine guys, they don't do that. So, but just to cover us, I brought this up last time, and I think it's very important because I spoke to one of my friends he's a lawyer, and he does malpractice with TMLT, and he said it's extremely important that we address this issue.
Madam Chair, a couple of things, observations. The conversation today relating to the composition or the criteria for being an advisory board member, that's not going to impact who we allow to be a ringside physician. That clearly is going to remain a licensed physician, and it has not changed. And Greg and them do a great job of vetting and making sure they've got that practical experience as it relates to that. And just briefly, I know Charles is getting a little worried about going off the agenda, but just very briefly, in regard to the malpractice issue, that's going to be a discussion we're really going to need to wrestle through in a work group and then bring it back to the full body. And that's something that, Madam Chair, we'll bring to you, of having the medical group talking about the malpractice, talking about the ringside physician training, qualification, the forms. I mean, those are all tight little issues that have to be wrestled here and then come back up to the full group. But that is definitely on the plan.
So, Blaine Seville, so Brian, I was going to address that. I think, obviously, the chiropractors, they feel some kinship. There are probably a lot of those guys that are seconds in the fight and stuff like that, but that doesn't change who's at ringside, who's treating
Correct.
medically.
That's correct.
And so that, I think that's an important distinction.
Absolutely.
And so, other than that, I think they're asking for participation. I know, having done about 12 years of amateur combative sports myself, I know the guys are in there, they're training, and a lot of the guys go to the chiropractors, and so I see the connection that they're trying to make. But
it does not
the
exchange
clarification
from
that you're
ringside,
making, there's no
absolutely.
bearing on, treatment at ringside.
That's correct.
Madam Chair, if I could add something. This is Lee Parham, Regulatory Programs Manager. Dr. Gonzalez, since the last meeting, program staff has started research on the malpractice issue. So just to let you know, we're working on it, getting everything we can together before a work group is put together.
Thank you.
Thank you, Lee. Other comments?
And I guess to conclude, we'll take, even though there's been no official vote appropriately so, we will take the comments and weave them into the thought process, present that to the commission, and ask that the rule be adopted with any tweaks, which I don't foresee any, but that the rule be adopted, and we can move forward with actually getting the members appointed and moving on with the rest of the business of the board.
Thank you, Charles.
Thank you.
Agenda? Okay. Are there recommendations for agenda items for the next meeting?
Madam Chair, I think the next meeting, if everything goes according to plan, will be the inaugural meeting of the newly composed board. The timeline is going to look something like the commission taking it up at the next meeting in February, making the final adoption, probably having the rules effective March 1. Then March, we will start canvassing and sending out the information, soliciting applicants for the positions, and then probably have appointments made sometime in April or May. So it'll probably be a June or late May meeting for the new board. So that's going to be the game plan. So we'll probably have orientation and all that stuff on there.
So I take it that we do not need to discuss the date, time, et
No,
cetera,
ma'am,
of the new
it's
meeting.
not
It will
necessary at
be
this time. But
Perhaps a new group, or at least partially a new group.
absolutely, we'll definitely keep you in the loop, Madam Chair.
Well, if there is nothing further, then we will adjourn the meeting at 10, everyone.